Enacted in 1988, the Benami Transactions Prohibition Act bars Benami transactions and gives government the right to confiscate Benami property. Benami is a Hindi word which means without a name. A Benami transaction is carried out on a fictitious name, or the real owner buys it on someone else's name to make profit and circumvent the tax laws. The Act says that a Benami transaction is a deal where a property is transferred to or is held by a person and the consideration for such property has been provided or paid by another person. It also includes transactions where the property is held for the immediate or future benefit, direct or indirect, of the person who has provided the consideration. In simpler terms, if A has paid for the property but it is in the name of some other person B, it is labeled as a Benami property. Here, if either A or B are fictitious, the property is considered a Benami property. This also stands in the case of the owner denying any knowledge of holding such property. Cash and sensitive information can also be termed as property under the Act. According to Section 5 of the law, the Centre can confiscate any property that has been tagged as a Benami property. But there are some exemptions in the law. When the property is held by a member of a Hindu undivided family HUF on behalf of the HUF or on behalf of his spouse or children, it cannot be considered Benami. Also, if the property is held in a fiduciary capacity, it does not come under the ambit of the law. The major point of contention here is the amendments to the Act in 2016. Let's have a look at the amendments. The amendments that came into effect on 1st November 2016 inserted a subsection 2 in section 3 of part 3 of the Act. It specified that whoever enters a Benami transaction shall be punishable with imprisonment for a term of up to 3 years or a fine or both. This has been termed unconstitutional by the Supreme Court. What has the Supreme Court said about the law? Supreme Court bench led by CJI N.V. Ramana on Tuesday stated that the provisions under Section 3 are unduly harsh and declared them unconstitutional. The provisions under Section 5, which allows the government to confiscate the property, were also declared unconstitutional as they were half-baked. If you like this video, share it and subscribe to Business Standard. For more news, views and insights, log on to www.business-standard.com. Do also follow us on YouTube, Twitter, Facebook, Instagram, Telegram and LinkedIn.